The next matter to come before us this morning is State of Ohio versus Stephen R. Moore. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve that time and let me know when you get started, I'm keeping the clock this morning and keep you apprised of the passage of time. The court has read the briefs and we're ready to see when you are.
Thank you, Your Honor. May it please the court, my name is Stephen Hanadell. I represent the appellant Stephen R. Moore. I'll reserve 5 minutes for rebuttal. I took over this case for Paul Griffin after he quit his prior practice and left the prosecutor's office on December 1st, and that was after the briefs were filed. So I am going based on what Mr. Griffin had filed in his brief, and based on what he's argued in the brief about the manifest way of the evidence that the victim in this offense, that Mr. Moore was seen, taking scrap materials from the residence or from the property of Henry Husk's son. Mr. Husk was the victim in this case, and when Mr. Husk showed up to the property and confronted Mr. Moore and the co-defendant, that's when there was a scuffle where Mr. Moore tried to break into the car, and also I believe the co-defendant ran the pickup truck in Mr. Husk's car in order to get out of the driveway and leave the property in order to flee. Where Mr. Griffin has assigned error in this case is the manifest weight of the evidence regarding the serious physical harm that's suffered by Mr. Husk, and that's an element of the aggravated robbery offense that Mr. Moore was convicted of, because Mr. Husk said that Mr. Moore had dragged him from his car by pulling on his arm so severely to cause a rotator cuff tear.
Was that at the same time that Mr. Samples was backing into the front end of his car?
It would have been in the same time frame, yes. And I believe, I can't remember which one happened before the other, as far as whether the co-defendant, I believe, was driving the truck to try to get off the property and try to ram the car out of the driveway. And sorry, I can't recall which one happened first, but
could they have been contemporaneous?
What's that?
Could they have been contemporaneous?
Well, maybe, but I think what we're looking at is a serious physical harm component, and we're not questioning the conduct by Mr. Moore in the sense that he committed criminal conduct that day, and in fact he was not disputing the breaking and entering and criminal damaging that occurred. I think that where the question is regarding the credibility of the serious physical harm component, because Mr. Husk, at the time that he reported the offense to police, the crime to police, he did not complain about having any problem with his shoulder. Police, per the prosecutor's brief, the police had said he was very hyped up. Afterwards, he chased after Mr. Moore and the co-defendant for quite a while. And so, if we're going to talk about serious disfigurement, where they said after his shoulder surgery, where he couldn't move his shoulder for 3 months. Well, that wasn't the case at the time that the offenses occurred, where he was able to, get in his car, chase after him, and call the police and do all sorts of things. Didn't report to the police about his shoulder, being in any great pain or being disfigured. That didn't come about, or not yet, not even in the witness statement or even during the preliminary hearing. He didn't even say anything about his shoulder being disfigured.
But didn't he go to the hospital later that same evening for treatment?
I just know he went to, according to Mr. Griffin's brief, the first time he mentioned being dragged by Mr. Moore was when he went to see Dr. Cerna, and he was the one that diagnosed the rotator cuff tear. And so,
but he was treated, wasn't he? I'm not talking about whether he specifically said my shoulder was hurt, but wasn't he treated on the same evening?
I do not know, to be honest with you. Like I said, I took over this case after the briefs were filed. So, but even if that was the case, then there's still the issue as to whether the shoulder injury came up as an issue. And the backdrop of all this, that he worked 36 years for United Airlines carrying baggage, and which involves very heavy use of his arm, very heavy use of his shoulders. And in fact, he did, have a previous rotator cuff tear in his life from working for the airline.
Wasn't that the other shoulder, though?
I can't remember.
It was his right shoulder, not his his left shoulder, right?
The right rotator cuff was torn in. The right rotator cuff was torn in his in working for United Airlines.
That was on his right arm, not his left arm. That was in the driver's side window that a motor came in.
That would probably be correct. But nonetheless, I mean, the wear and tear on, when you do the kind of intense physical labor for that long, there is wear and tear in your body to where, you're just going to be, you're more susceptible to injury just even over the littlest things. And as I'm starting to learn the hard way as I'm getting more into my 30s. But as far as the fact that if Mr. Husk is saying that he was dragged by Mr. Moore in the fashion that he was, you would think that he would complain about the disfigurement of his shoulder right away to the police in the hospital and in the preliminary hearing, not until way later. And so I think that's where the issue is in terms of the credibility of him all of a sudden saying now, my shoulder was disfigured in that, when we don't know, it could have been something else, especially when he didn't complain about it at the time.
Except that we have an expert witness, the surgeon who actually did the rotator cuff surgery, who testified at trial, right?
Yeah.
And he testified that this was not a chronic injury or a chronic situation. This was something that was traumatic. So that would tend to support the causal connection, wouldn't it?
Well, and I think again we're not saying that I think we're getting to the serious physical harm component versus physical harm, and we're talking about serious physical harm means there's got to be a temporary serious disfigurement, which he definitely had after surgery. I think the question is that at the time when he said nothing about it, and for quite a while he said nothing about it until way later, and I think it called an issue with credibility and the fact that he ended up having surgery. Those medical bills are going to cost a lot of money. He did end up filing a civil suit against numerous parties, including Mr. Moore.
Is any of that in the record before?
I do not believe so, but and I don't know if that issue came up as far as his testimony, but certainly there's motivation to want to say that this was purely caused by someone else, because if you can recover damages for that, then that's all the better. And so I think that's at least the attention that Mr. Moore and Mr. Griffin are calling to this court's attention about just the credibility of Mr. Huss saying that he suffered serious physical harm at the hands of Mr. Moore, and that would call into question the convictions for the felonious assault and the aggravated robbery.
And this was a jury trial, too, right?
Jury what?
It was a jury trial?
Yes, well, I believe so, yes. So, and that's pretty much all I have for now. I'll reserve the balance of my time. Thank you.
Good morning, Your Honors. Mary Solanska on behalf of the appellee in the state of Ohio. With respect to the serious physical harm element, I believe that the state provided evidence that supported the jury's decision to convict Mr. Moore of this offense. I wanted to point out in the trial transcript at page 221 to 223, this is regarding the medical records from the treatment that Mr. Husk sought the night of the incident. He disclosed to the treating medical personnel that the defendant had jerked him by his left shoulder. So that's the first point. It's that night. Deputy Golick testified that when he arrived and spoke to Mr. Husk was, quote, hyped up. He was, kind of on I guess, an adrenaline rush from what had occurred, that he catches these people, they're ramming his car, he's following them while he's talking to 911, and he's been, he's gone through quite a lot. So I don't think that it would be uncommon for someone to not mention, if the shoulder may have just been sore, and it wasn't until he got home and maybe, he's raising his arm to drink out of a glass, or he's doing something that he starts to notice it's more than just a little bit sore. I better go get it checked out.
Was he treated and released, or was he admitted?
He was actually admitted overnight for observation. you know, the medical records kind of speak for themselves, but I think the fact that a doctor would look at that and say, you know, given what's happened to you, I'm going to admit you to the hospital. And it's at that point that he first complains about the pain in his shoulder. And as far as the not being able to move his arm and the length of time that he was incapacitated, that all comes about a month later when he goes through the surgery. And of course, there's going to be, you know, restrictions on what he can and can't do, and he's not able to move his arm. Just because it comes after that surgery doesn't mean that it's not the serious physical harm. All of this stemmed from the incident with the defendant and the defendant jerking on his arm and throwing that small motor through the window, which I believe Mr. Husky testified actually did strike him in the arm. You also have the testimony of the orthopedic surgeon who said, in his medical opinion, to a reasonable degree of medical certainty, this injury was acute, meaning it occurred suddenly. It's a traumatic injury, not something that's chronic. And he was cross-examined at length about the nature of the injury, and you know, it was suggested to him, isn't this something that could have been from his baggage handler days? You know, he did have an injury to the right arm, and isn't it consistent he'd also have this? And the doctor said, no, this was something traumatic, it was acute. It's not a long-standing condition that's developed. So I think that the state's evidence was extremely persuasive to the jury in this case to support the conclusion that the victim did suffer serious physical harm as a result of this robbery.
Well, to that point, if you look at the definition of serious physical harm under the statute, which of the paragraphs, or not paragraphs, but the letters, A through, like this is E, is the state claiming that it proved that element under?
Well, I think if you look at what I've cited at page 7 in my brief is 290101A5C and E. So those two incidents, that serious physical harm includes physical harm that involves some temporary substantial incapacity, and I think 3 months without being able to move your arm would be temporary substantial incapacity, and physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. And the victim testified about the pain that was caused to his arm. And I think under both of those subsections, the state met its burden to prove, and the jury properly found that the victim did suffer serious physical harm given the length of time to recover from the injury, the fact that he had to undergo surgery for it, and the pain that he indicated that he was in. I think when you look at all of that evidence, this is not a conviction that we could say that the jury lost its way in finding the defendant guilty of the two offenses involving the aggravated robbery and the felonious assault, which both hinge on the serious physical harm. I think that the state did meet its burden to produce sufficient evidence, and that evidence was persuasive to the jury, and they convicted Mr. Moore. I think based on that the jury was proper in doing this, and that this court should affirm the convictions and sustain overrule defendant's assignments fair. I don't want that to happen. Thank you.
I have nothing to add until I waive rebuttal.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted on our website and